Good morning, Commissioners. Kyle Fenner, Director of CDS. I want to kind of just bring you up to speed on some progress. You'll see several things coming to you for your approval, but of course the big one, I think on everybody's mind, is oil and gas and where we are in oil and gas. And I'm going to touch on history and some dates and remind maybe you and the public and anybody listening on where we left it. Where we left it, of course, was July 10th at the meeting and the directive from you. Am I speaking loud enough, Commissioner Ross? Okay. And the directive was for us to kind of, us being the department, to create a process for which the county could undergo using the MOU, because our current regulation did not allow for that. So where we are now is the county is working on that. But I want to bring you up to speed on some changes at the state level and also say that's a bit why we're delayed and give you a timeline and set some expectations for you and for the public. What I would like your blessing on, or your, I'm informing you and I would like you to agree with the process. The process is that it's back with CDS. We want to re-engage the Planning Commission. It is my belief that the Planning Commission will have what I'll call a straw man format of this to start working with. And that will probably be in the Planning Commission's hands 10 days to 2 weeks. Then the Planning Commission will have their process.
From now or?
No, 2 weeks from now, correct.
Oh.
Correct. And part of what's going on is that the state laws have changed. And the way I've got sort of a synopsis, and I'm going to follow this because it's a little bit confusing, and I'd like everybody else to be able to follow it. The bottom line is the COGCC regulations give now the LGD, which is the local government designee, a great deal more power over how Elbert County is regarded at the state level. And all of the work that was done in the 2 years prior to now has sort of led us to understanding how that relationship works, monitoring how that relationship works, and staying abreast of the changes that are happening at the state level. And this is an opportunity for us to leverage the new state laws to involve Elbert County in the permitting process so that it actually benefits Elbert County specifically, because our LGD represents us. That LGD is the spokesperson, but by no means does that LGD not use the resources within the county in order to negotiate this. The LGD can also extend the approval process. So if we feel at any moment something isn't happening the way, or we haven't been given enough time to evaluate something, we can certainly extend that approval process. BOCC guidance should be available to the LGD about how and when to exercise those new authorities. But the process that I want to outline now is that it needs to go back to the Planning Commission. The Planning Commission needs to be able to sit down, evaluate, rework, try on, troubleshoot, and then it comes back to the BOCC. So I really want to go back to re-engage and reaffirm the process. And I would like your blessing to do that.
Are you prepared to go directly into this plan of collaborating with the Planning Commission?
No, right now, yes, in process. But what I believe, it's going to be 10 days before there is something to actually work with. It's going to incorporate what is so now at the state, because that changes what was. And the directive was we're also going to be working on that MOU. And what I'm trying to make the point is that at the state level, the way the state regards the counties via the LGD process has changed how those regulations and how the MOU relates to them, how it should be formatted probably. And we're looking at some format changes, more likely.
And I understand that this process will evolve over time in various different ways. We'll have to be able to promptly react to those changes as they occur.
Right.
My question for you is a date certain when you will actually be engaged with the plan?
I don't have a date certain. That's why I'm saying 10 days to 2 weeks.
Okay, you're saying 10 days to 2 weeks before you're sitting down with these.
Correct.
Okay.
And then they have their time with it too.
Okay. Now, when you present it, or get to that point, is that the official presentation to the?
Nope,
planning
nope,
commission?
that's when we start working together.
Okay, so the timer, the 30-day timer on them does not occur
Correct.
until another uncertain date in the future.
Correct, and we'll determine, when they get handed it, we'll make the announcement that they've officially handed it, and I think we can actually get together on that. But that clock does not start ticking until they're officially working on it.
That may be a month still down the road then, before the timer begins on the planning commission.
Not likely a month, but their time is going to be defended by me. They will have their full 30 days, if that's what we're getting at, and I'm not quite sure where we're going with this. So I apologize for my
No, just
confusion.
to lend as much certainty to what you're going to do and transparency to the public about your plan as you're legally allowed to do.
Correct.
Okay, and that the process will then not begin, it's still on your desk for another
Correct.
couple of weeks.
Correct.
Then you're going to.
And that's not being counted against any clocks.
Okay, and from my point of view, I'd like to have something at least roughed out so I can put it on my calendar as well.
Okay, and actually what I'd like to do is get together a planning commissioner and see how we can rough that out to your satisfaction. But right now I can say 10 days to 2 weeks before there's a draft for that group of people to look at and do with what they want. The clock is not ticking now on anything, and we will be certain collectively to determine when that clock starts ticking. But I don't anticipate it being much beyond when they receive that.
Now,
We'll do that in a formal meeting, of course, it'll be presented to them.
And looking down
And
the
it will be
road,
publicly noticed.
looking down the road, I mean, we wouldn't be going through this entire exercise if it weren't in anticipation of processing drilling permits.
Correct.
And-
We actually, I'll bring you up to speed, we probably have one sitting at the state right now.
That's my understanding.
Yep. It was either going to be a yesterday or the day before.
When we reach a particular point where it's important and necessary, in my estimation, for legal counsel to review the document, that recommendation for who that particular lawyer or lawyers may be will be then coming from this board here.
No, it will go to the planning commission. The planning commission will have, the planning commission and staff. Unfortunately, the BOCC does not have a role there to tell the planning commission or
Okay.
staff.
So the planning commission then would select an appropriate legal counsel to review the
No,
documents?
no,
So you're don't have any plan for legal review of the document?
absolutely do.
You do have a plan?
Yes.
And what would that plan
The
be?
plan will be the county attorney will review it for its, prior to it going to planning commission, the county attorney will review it for its legal supportability, defendability as it relates to the current land use code. If the two are in conflict, the county attorney will point out whether or not we have opened ourselves up for violation of our own code. That's
And
what.
this is not to diminish Mr. Belton's capability as an attorney. However, given the gravity of this and the specialized nature of the oil and gas regulating business and so forth, I want to be on record as saying an agreed upon independent counsel should have a final review and comment of this document.
Well, you can put that on record, but I don't think that you can mandate that of the planning commission. I don't believe that you can do that.
Well, ultimately, it will come here for a vote.
Correct.
My comfort level relies on having it bulletproof from a legal standpoint.
And I understand
And I
that.
don't think that's an unreasonable request to make.
I agree with
Fundamentally,
that.
how we go about arriving at that, we'll work it out.
Correct,
I
but-
just want to make sure that, and this is no offense to Alex whatsoever, but I think he would probably agree with me that his area of law is not particularly in mineral extraction or interface with these other government agencies. It's not something he does every day. There are a lot of people that do.
Correct. But again, I think that that would be the discretion of the group that's reviewing it prior to your review. And then
Okay.
yours.
So I'll look forward to that timeline,
Okay.
and good luck. Thank you.
Thank you very much. I'll need it.
Right. Thank you. is interesting to hear, and I'll be anxious to learn more about this new state law and I believe you used the term, additional leverage that it gives counties through the LGD process. I always believed, and I don't want to get into a debate about the new laws because I haven't seen them or read them, but I appreciate the link if you got it. We talked about being able to extend the process through 228 when they apply for those permits at the state level. I thought we had that authority already, or the LGD had that authority already.
You do. Well, you do have it. And let's clarify, the 2 is downhole, 2A is surface. So we're really only concerned with the 2A. So just let's, get clarity. Yes, they've always had that, but there are more days that we can extend it. So
they've lengthened the time?
They've lengthened the time that the LGD is got jurisdiction/power to halt a project for further review.
Absolutely. It's still a defined length of time. It's not infinity.
It's not infinity.
It's the length of time. So they've increased it. Okay. And you talked about the process now having and correct me if I'm wrong or if I misunderstood, you said that increasing the board or the input or guidance to the LGD from the county or the board of county commissioners would be the logical assumption. Wasn't that in place as well already?
Yes, it is. Absolutely. The LGD has never worked in a vacuum. So that what I'm trying to do is probably repeat what things have been repeated for the public to understand, that if we are putting our faith, quote unquote, in the LGD process as being something that is strengthening the county, that they understand how that LGD is informed by the people of the county, whether it's the BOCC, whether it's the Planning Commission, whether it's the people at large, it's all that, but the channel being used is that LGD process, and that LGD is getting stronger and stronger as a representative of county.
Good. And there's been some talk, and I'll speak just for a moment to the issue about the legal review, but I think it's important, and this is, I'm going to state my opinion here, the process, and for the public's information and for everybody's information, the process is that these things come from your department. Planning and Development develops these proposals.
A basis?
Sure. A basis, the foundation. With legal review, which I believe our attorney is competent and able to do that. And any additional contracting of outside legal services would be a decision for the full board, obviously. That having been said, the process then, as you described, within the next 2 weeks, I think you said 10 days.
10 days to 2 weeks. Don't hold me to the 10 days. That's why I'm buying the 2 weeks as well.
So then you, as we've always done, would send that to the Planning Commission.
Correct.
The Planning Commission is currently a board of 7 members of the committee, the Planning Commission.
Of which there are attorneys, of which there is a great deal of experience.
They all bring their expertise to the table, clearly, but they are a Planning Commission that will ultimately have the goal of rolling out of this, bringing that recommendation and or that proposal to the Board of County Commissioners within a 30-day period, or by a 30-day period, for again, a review, a vote, consideration. That's the process. Those are the team players in the process.
Yes, as outlined.
Okay. And I think it's important to define who that team is.
Okay.
Are there any other members of that team?
I'd like
an
to.
Editing committee.
Well, there's been an editing committee to date.
Okay. But it's the Planning Commission's responsibility to bring that to the board once that 30-day period is done.
Yes, it's the Planning Commission's responsibility, absolutely, but I don't believe that it's within the BOCC's purview or mine to tell the Planning Commission how they go about gathering their information and the resources that they utilize. In
an informal setting, there's clearly anybody, we all bounce ideas off of folks that we trust and consider confidence. And I wouldn't argue that. It would be ridiculous to do so. But in a formal process, the process is your department, which could include legal review internally, because you have access to the county attorney, the Planning Commission, and the board.
Yes and no. And here's what I'm going to say. And here's the yes. That's the high level formal. I've done a little bit of research and understanding the process as it is and as it is. This is the as-built, so to speak. is that there is a formal editing committee that has been endorsed and actually asked for by your predecessors. The Board of County Commissioners requested of Richard Miller to engage an editing committee, to both select members and engage that editing committee as a subcommittee or partner to the Planning Commission. So in this particular case, that has been the embraced format of this. I believe that should the BOCC moving forward choose not to engage editing committees in the future for future projects, that is certainly within your purview. I would believe it would be inappropriate to alter the structure of what it's been for 2 years simply because we're making another attempt at it. I mean, this is the group of people that's been engaged. And if we want the historical knowledge, and if we don't want to throw the baby out with the bathwater, this is the group of people that came up with the first set. This is going to be a second attempt with new laws in consideration, so it's going to look different when it comes to you. But the fact of the matter is that if we eliminate that knowledge base, I think that we're cutting our own arm off.
So your recommendation is, and let me say for you and everybody else here, you are our planning director. You are tasked with these responsibilities, and we trust you to do those responsibilities. And I respect that opinion, whether I agree with you or not. But your recommendation is that we maintain the process that's in place now for this particular project.
For this, I would ask that you allow the Planning Commission to operate the way that it has operated through this project, unabated. Yes.
Ms. Fenner, you prefaced all your remarks with something to the effect, I kind of like your blessing on this.
Yeah.
I approve of the approach that you're taking, and I'm learning as I go as a new commissioner that commissioners must remain hands-off, arm's length from these processes for a good reason. Okay. Then when the product comes back, yes, we can mark it up and send it back. There's a number of different things in order to iron the kinks out, and that's all we're really trying to do now is back up a little bit, work out some new issues that have come to light with the state regs, hopefully create a document that reflects the unique topography, nature, complexion of our county, which is very, very diverse. But beyond that, and getting into specifics, then I would be crossing a line that's not appropriate. But I will look down the road towards what we're ultimately trying to do is create a process for permitting these wells and associated facilities that have varying degrees of impact on land use. And that's pretty clearly defined by the state, that downhole operations and all that other stuff, and there's a lot to it, is outside of our jurisdiction. We're talking about a land use thing, and that's why it lands on your desk, because land use and zoning is what we hire you to take care of, and representing the people of the county first and foremost, and protecting the land and wildlife and everything else. Okay. All that being said, and that it's somewhat new territory, we may come up with something that is absolutely unique to, I would hope, tailored to our unique county. Okay. And involving an MOU process which inherently has a negotiating aspect to it. Okay. So you would want an advocate who best represents and is most knowledgeable on the subject matter at the table by your side, negotiating with Mr. Oil Company to get the maximum number of protections for our land use that are reasonable. Okay? Because reasonable care is the standard that's employed by the legal community, I think, in terms of extracting minerals for both sides. And so that being said, I will say again that when it comes down to that point, that we should have additional help by your side who is expert in the area of petroleum geology, land use, zoning, all these issues to assist, to derive the best bargain. That wouldn't be necessarily an ongoing thing, because once we've got people with several deals that are in different sectors of the county, then we'll have a pretty good established template to process these things. But initially, I think the additional help would not be rejected or objected to by any sensible person.
No, and I agree with you, and I believe, my hope is that the regulations that you will see before you, coupled with the other MO, all the pieces, parts of this, if we do it as well as I believe we can, as the Planning Commission, that the first handful of them, you bet you need some support, you need somebody who's been there. If we craft these very, very well, you're right, it will become we really know that region, and it's a fairly easy, if they're like projects.
I want to say one more thing about this.
Okay.
Because I'm really enthused and excited by the number of professional, disciplined folks and others that come forward to offer their time for free for the betterment of the county and to get involved in their government process and so forth. And call it a setback or disappointment or just we needed to take another swing at this thing, whatever it is. I don't want anybody to be discouraged from coming forward and lending these tremendous talents, because it produces a better product and it produces consensus among our population on a very controversial issue. And I think that's an asset that money cannot buy.
I agree.
Okay. So utilize them, please, and
They'll be wishing that they know.
I wish you all the best luck.
Thank you.
And I'll close real briefly. I also am encouraged that we are, this is a long, arduous road that we've been on, and we all know it's controversial and whatever else you want to call it, but it's an important time in our county, and we're encouraged by your leadership and your interaction. I want to reiterate once again, this is your job, your responsibility, and we trust you to do that, and we'll continue to do so. I would like to make one technical point, though. When we call these oil and gas regulations, they really are an amendment to the zoning regulations.
Correct.
And I think we need to keep that. Okay?
And they cannot contradict anything else that contained.
But thank you, folks. And everybody.
Yeah. Thank you.
Whatever.
Commissioner Scheibel, anything?
You bet. It's my turn. I don't have any questions. I just want to thank you for what you're doing. And I want to clarify. Several weeks ago, when we went through this machination and we turned down that recommendation from the Planning Commission, the motion that was made and subsequently passed directed staff to develop that process and then to go through the adoption of that process. Never was it ever said, nor can we bypass the Planning Commission. And I want to make that perfectly clear, that anything that staff develops must then be approved and formed by the attorney to the Board of County Commissioners, then goes to the Planning Commission for their review. They have the option then to either accept, to recommend, or to recommend accepting by the BOCC, to recommend that it be amended, or to recommend that it be denied. That's never changed. That's the state statute. We must follow that. As far as using committees, I am not in favor, and my position has never changed, and it will not change. We do not govern by committee. When we look at regulations or modifications to our zoning regulations or any other official document, it's done by staff, and then it's put out for comment, whether it be through the Planning Commission or just for a 30-day or whatever period it's assigned for public comment. Then that's either modified based on that comment period, or it's presented to the Board of County Commissioners as it was developed. I do not support, I will not support the use of committees. That is what the Planning Commission is. They are appointed by the Board of County Commissioners to review things that are developed by staff, and then they make that recommendation to us, whether we accept, reject, or modify. I'm glad to see that it's moving along. I'm pleased to see that it's moving along. And I think that the use, we talked about the use of the subcommittees or outside help. Any meetings that you have with the planning commission, and I will ask you a question, they're public meetings, correct?
Correct.
Anybody can attend, correct?
Yes.
And is there usually a public comment period so people can have their, they can express their beliefs or what they would like to see?
Yes.
So that alleviates the need for having a subcommittee to a committee to an advisory committee, does it not? I don't want to ask you that. That's my opinion.
Because I would just be repeating myself.
That's my opinion.
Well, I appreciate your opinion.
Perfect.